Hello, everybody. Hey, very nice to see you all. Familiar faces and some people I haven't. Maybe we're at the party last time, but didn't get a chance to talk too much. Hello, everybody. Thanks for joining. I was asked to talk today about new builds, whether it's a detached home or brand new stratas, but mostly about detached homes and some issues relating to that and leaseholds as well. So a little bit about myself. Next screen, Calvin. So next screen. So I'm a real estate lawyer. I've been practicing for 25 years. And actually, I think in about, what day is today? May the 18th, 3 days, it'll be 25. We should have a celebration. Okay, awesome. Anyways, so I do all kinds of real estate, whether you're selling or buying, commercial, developing, and construction issues, which is what we're going to deal with a little bit today. Okay. So the topic today, buying and selling new pre-sales and also new builds and stuff. So detached homes first to begin with. Next screen. There are a couple of issues I want to talk today about. So next screen. So we have builders lien issues, there's deficiency holdbacks, there's dealing GST issues, as well as new builds dealing with leaseholds. And there's a lot more things, but I just want to pick on a few things that seem to keep popping up as an issue when it comes to my practice and with clients and different realtors as well. And the issues do keep coming, and they're important ones to know. And one of the biggest issues when it comes to new builds is builders liens. Now, a couple of things I want to point out, and we can talk about some examples later on. Who can file a lien on a property? It's not just builders and renovators. Those are most common ones, people who are, but the general thing is to say anyone who has supplied labor or supplies. Now, work as well as actual products that are put onto the property to improve a property, and that person has not been paid, can file a builder's lien. Renovators, you can also have contractors for the landscaping. You can have not just a house, but anything on the property. Someone to remove an oil tank, and someone who can probably to cut down trees even. So anything that relates to improvement of a property. Now there's also a deadline to put liens on the property, and to the contractors themselves, they have 45 days from the time of the project is completely done. So you may have, for example, a drywaller or a contractor for electrician that hasn't been paid, but their deadline doesn't really begin until the whole entire project of the house is done. So, you can say, hey, I got a bill here, they haven't been paid. When is their deadline to pay? It is not necessarily 45 days from the time that contractor finished, their subcontractor finished their job, is when the entire project is done. It could be if the project is only one thing, but if it's a whole bunch of things, when the entire project is almost done. Okay, so that's important to think about. There's a timeline, and I'll talk to you a little bit later, because when it comes to buying a home, buying a property, you actually choose 55 days rather than 45, and I'll talk to you about that in a few minutes. Okay. No, next slide, next screen, please. Yeah, there we go. So the idea is like, well, I mentioned a little bit about when a whole entire project can be completed. It's not a clear-cut case. It is not that simple. There are sometimes you have to look at a whole bunch of different sources to determine whether you can start the countdown. So some of the ways which is used commonly, which are indicators, is such as a certificate of completion by the general contractor who says it's all done, they're all been paid. It's something that most commonly is someone appointed by the builder in the contract to be the person to certify something's being done. Another common proof or evidence of a project being done is issuance of occupancy permit. The city has come and they've inspected, the property is safe to live. A caveat though, an occupancy permit from the city means that the property is safe to live in, but if the original or the whole entire contract doesn't have to be completely done in order for an occupancy permit to be issued. So electrical is done, it's safe, the structural components of the construction is safe, and occupancy can be done even though a few other things are not done, like the fencing is not done, there's a few door jambs not finished, there's a crack over here and there, it's not completely done. But so this is just one indicator of it. You're more likely to be done when you get an occupancy permit than not, but it's not conclusive, okay? And then sometimes when you buy a property that's a brand new build, that, for the sake of purposes of a buyer, when you're writing a contract to buy a property that's been done, you look at the date of completion of the purchase as one of the dates in which you can calculate the number of days for the purposes of a sale and purchase, okay? So another thing, no, next slide. There you go. So sometimes there's another formula which is common. This isn't, this is something that is a little bit more objective in terms of dollar wise, instead of like looking for evidence in someone. You look at the stage in which the project is being done. So it can be considered substantially done if 3% of the contract price is still left to be done. So, if the price of the contract is 500,000, there's about $15,000 worth left of work to be done. In terms of percentage wise, it's like 1.5% left done, but you can look at the dollar wise, and then you look at 2% of the next 500,000, and then 1% of the balance of the contract price as an indicator. Of course, there's all these components of a typical building contract, which indicates how much it costs to get to a certain stage, right? So you have this as an indication other than those other three that I mentioned, okay? So, you have an occupancy permit, you got a certificate of completion, and then you got, purchase date coming up, and then you look at this and is there anything left, Sometimes there's a few little things left and right, and you look at the value of what's left compared to the value of the whole entire contract to determine, is it almost done or substantially complete, okay? No, next slide. Okay, now, builder's lien, why even have it? Why do it? And what's the benefit of having some kind of a term in a contract that allows for a lien to be placed? So, in a typical building of a contract of a detached home, there's many people working on the property. There's plumbers, electricians, there's drywallers, there's people doing the concrete, the patio, the fencing. Every one of them has a price on their contract. So if you don't take advantage of allowing for liens and holdbacks to be done, you potentially, the homeowner could be on the hook for everything. But as long as they hold 10% of the value of each of these contracts or the value of the general contract's price, then they can be protected from paying the whole entire thing from everybody that's not been paid, okay? Then of course, there's different ways in which a person can organize their building contract. They can hire a general contractor. Everything flows through the general contractor. Sometimes the builder, the owner will directly contract with all these individual subtrades. And so then there's two different ways in which you do the holdback, from the payments to the general contractor. So, when contractor says, if stage one's done, give me X amount of dollars, hold back 10% of that. Or if the the owner of the home has like 15 different contractors, every single time they pay a particular contractor, hold 10% off that chunk that they were being contracted to give. Okay, so there's more than one way to do it, but the potential of that having to be responsible on the hook for everything when you pay a general contractor, and that turns around that the general contractor didn't pay all the subtrades, and then or didn't pay enough or didn't pay what they're supposed to be paid, then you protect the homeowner with that holdback. So next slide. Yeah. So, I mentioned about the different ways in which a builder can build a home or a house owner can build a house. So hire a general contractor who organizes and hires all the subtrades, okay? And then usually, of course, the contract to build comes in stages. You get the foundation, you start the structures and everything, and the roofing and the ceilings and the electricals and all that. So in this situation, the contractor has to or should be holding back 10% of the payments made to the, for the homeowner to give to the contractor, 10% to be paid. Hold it back. And make it sure that any contract with a contractor, general contractor, to have that provision built right in. So there won't be any disputes coming in where the general contractor says, hey, maybe this is a good segue to talk about when you hold that 10%, because the general contractor can say, look, look, I hold back 10% of the value of the contracts at the very end of the project. So the very final chunk of money, they have a 10% of the whole entire contract price, and they hold it back at the end, rather than each individual step of the way. And so it should be very clear in any contract how exactly is the builder's lien gonna be held back. So don't make any ambiguity. So the homeowner, for example, says to the contractor, I'm holding 10% now. The general contractor said, hey, that's not in the contract. I hold it back at the end. And that could be, that is sometimes a potential, and it is quite a common situation that arises where there is no discussion of when the holdback is to be done. Okay, so and in my estimation, that in terms of when and how it's supposed to be done, you hold 10% off along the way so that you'll never be short by the time of the end of the contract. Yeah, that, but that's just what I prefer, and I think it's safer that way too. But that's not how everybody does it. Of course, the builder, probably a general contractor, wants all the money and hold it back at the end instead. So there is this kind of a conflict that sometimes occurs. Okay. Next page, next screen. So then the owner can hire, like I mentioned about hiring the subtrades directly. And if they coordinate it from each payment to each subtrade, hold 10% back and put that into each contract you have with each subcontractor, okay? As I mentioned before though, when you're finished with it, then it's hard to know how long do you have to wait before a lien can be placed on the property, if a contractor or subcontractor was not paid. Okay, so when you're doing all this and there's those contracts everywhere, when do you have to hold back and how long does that period begin? So it's harder to know that when you are as a homeowner, or if you were hired to be a project manager, to determine when the time frames and accounting time, the time to count starts. Okay, next slide. So, so say for example, if lien filing, somebody did file a lien after all, okay, whether it's legitimate, not good, or whatever, something is old, and they file a lien on the property, and you find out about it. Now, lien, it's important to know that a lien is supposed to be security for an amount that needs to be paid to a contractor. It is not meant to hold up the property as a ransom in order for the contractor to demand payment. So in the event, in the event that you guys may be in a contract where you are representing the listing, the listing owner of the house, and you're the listing agent, during the process, you did a search as you customarily do, and besides everything, and you found out, hey, there's a builder's lien. What's going on? And sometimes it comes out of nowhere. Like, there was a dispute over something that was done to the house. I repaired my fence, and we have a problem and dispute regarding the quality of the wood being put in there. And I wanted treated wood, and they put in untreated wood, and we're fighting over it, and it's like $10 off. Then a lien gets popped onto the property worth like thousands of dollars. I'm not talking about legitimate or not legitimate, but it may pop up when nobody would expect it, and you think it's such a small deal, then all of a sudden it shows up. So it shows up, and if you have a sale that's ongoing, you don't have to be too worried in terms of how on earth are you going to remove it before completion. Your buyer comes to you and you look at it, hey, there's a lien, there's a builder's lien, what do I do? How much of a problem is it? So lien on one hand can usually be easily removed just by paying the amount claimed into court, or having the lawyers involved do a trust condition to hold back the funds as security for the amount claimed. It's not saying that you admit liability if you do a holdback. It's not saying that this is this is something that you've lost, but it's the value that's being contingent, not the whole home. So if you put that money into court or hold it in somewhere safe where it can't disappear, that's easily, for 99.99% of the judges, when they hear an application to remove a lien, they'll remove it if there's security sufficient for the lien. And not saying anything about whether it's valid or genuine, you have a dispute, that's way too much or whatever, but that's just the way it is. You can have holdbacks from the sale proceeds to put in the trust to take care of it. And if the lawyer for the lien claimant disagrees, no, I want the money in my trust account, or I want it released. Well, they have a fight, well, go to court, remove it, because there's uncertainties about having a lien on the property that you can't remove. Take care of it so you can sell the house. And if you're a buyer, there's a lien, okay, then you don't want the buyer to be saddled with a lien. Take it, the seller has to remove it, do whatever they have to do to remove it, stick the money in court, hold it back in trust, remove the lien, okay? But it's important to know that the lien is not supposed to stop the passage of a transfer of a house from a buyer to seller. The liens is not meant to do that. It's just to secure the amount owed. And if you put the amount owed as security, then instead of the house, it'll be easily removed, okay? It's just as a hassle. It costs money. You make an application, you go to court, and if you can make an agreement, perfect, right? But if not, then you have to go to court. But if you go to court, it may be costly, but it's most likely granted, right? So it's not like if you have a listing, you're the listing agent, and you have an owner guy's like freaking out, what's going on, okay, don't worry too much. It's maybe $2,000, $3,000. You get the application to court, you file the monies in there, and then you're gone. Okay. So not to be too worried. It's not meant to hold the owner of the house ransom, regardless of it's legitimate or not. Okay, overblown, exaggerated. That was just a doorknob. What are they charging $2,000 for? Okay, regardless, you don't want to deal with it. You want to remove it. You don't want to negotiate. Okay, take care of it. Next slide. Okay. Yeah, I just mentioned, well, hey, a doorknob, $3,000. What the, you can put in your expletives here and there, but I won't. So, like I mentioned, it's supposed to, it's not meant to be holding the home as a hostage. No, there's something else that the homeowner can do. If if you got a couple of months left to sell the property, and there's a lien that shows up, and you're getting the property ready, you're getting the stagers coming in, you're getting it ready, and then you realize there's a lien. Okay, well, the homeowner has another way to how to say, force the hand of the lien claimant to put what they gotta say here, put the money where the mouth is. Okay, so what does that mean? Well, under the Builders Lien Act, in the event that you do have a provisions for this, and you've got the whole back in, you can notify, you can send a notice to the claimant, say, hey, look, under the Builders Lien Act, there's a 21-day notice period, which if you require the builder to put their claims into an actual statement of claim and file it in the court, then, and if the claimant receives this notice and doesn't file it into court, then you can do a search of the court registry and file it at the land title office saying the 21-day period has expired after the notice has been given, remove this lien, and boom, then you have a clear title house to sell. So the idea is that some claimants, they put a lien in. It's easy. You hire a lawyer, you write down a bill, you pay, you sign an affidavit, boom, and then you get a lien on the house. So the filing of a lien is very, very easy. It takes you like 250, 300 bucks, maybe hire a lawyer for 15, 20 minutes of work, pop it in. But if you more forced by the homeowner to prove it, then you have to file a notice of claim in the Supreme Court. You have to file it. You have to write down why it came about and how to prove it. Normally, you have to hire a lawyer to know how to do the form in which a claim on the court has to be done. Then you have to pay the 200 and whatever, 250 buck fee to actually file it into court. And then you got to serve it on the homeowner. So the idea is that, it's someone who's just filing a lien because, hey, it's easy, use it as a tactic to get more money than you should. Because it trust me, it does happen. Amongst litigators, it happens, and it happens a lot if they know that the house is being sold. And I would say that because I've done that too myself. Okay, I have a client that wants to, owes money. Hey, the house is on sale. Okay, look, wait, wait till they got a listing, it's sold, boom, then put the lien on, because now there's pressure on the homeowner who says, like, normally I wouldn't pay, you know, $300 for a doorknob. But if I paid the $300, the lien would be gone, rather than hiring a lawyer at $450 an hour to get the lien off and put the money in the court, and before it's like $3,000 to pay when the clean lien is only $300. And then really the value of what is really being claimed is only $50. So you can see where the thinking goes in terms of strategy. It's not right, but it hasn't been proven wrong. And what is used as leverage is the timing of the sale, giving pressure to the homeowner to give up, or because hey, it's easier, it's cheaper just to pay and pay them off and let them remove the lien. Okay, so the idea is that there is this provision in the Builders Lien Act to force the hand of the claimant. Yeah, hey, do you really mean it, or are you just trying to drag the chains of the homeowner to make them do something, right? Okay, next slide. Thank you. Thanks, Calvin. So you have a deal, you're acting for a buyer, and it's a brand new house, but you haven't checked anything in terms of when it was finished and when the occupancy permit was given. And then you realize, hey, what about builder's liens? Can there still occur? Can it still appear? Subjects already removed. I did an inspection. Yeah, everything's good. Subject to financing. Oh, I got the money. Oh, but we didn't really deal with it somehow. It does happen. Because sometimes you may not know, it looks brand new, but you were told, or maybe by the listing agent or the seller directly, that hey, this was built last year. And then you feel comfortable, but then you think, oh, hey, wait a minute. How do I know? How do you know for sure, right? So if subjects are removed, can you demand it? Is it by law? Because you think Builders Lien Act is a law. Well, it should be by law that we can follow the law. But unfortunately, the holdback provisions of the Builders Lien Act have not been enacted. It's been proclaimed but not enacted. So it's not enforced. And it's a mistake, I think. But there it is. Unless you specifically have the terms of a builder's lien holdback in the contract of purchase and sales, there's no right on behalf of the buyer to demand that it be put in. Okay, then you're at a risk. You're at a risk that a lien gets put in after the purchase, and then you have to deal with the lien claimant as the new owner. Okay, and that's the very. I'll tell you a little bit of a case that I've been working on 7 years after a lien has been put in, just to tell you how bad it can get. Okay, because it's a horror story, but it's a good one as a lesson. Okay, not to do that if there's a potential, even a potential chance that this, despite the assurances of a homeowner that or listing person that says this is hey, the end period of time is done, put it done. In the event that the property has been substantially completed prior to the completion date, then there would be a holdback. And you'll get some pushback from sellers. Hey, I don't want to hold back. What am I doing holdback for? But if you can, put it in if there's any potential chance, okay? Because it's not statutory. It's not required by law. You can't just say, hey, I follow the law, do what you have the law. Not like Residential Tenancy Act and tenants, So anyways, next slide. Yeah, we mentioned something about improvement. So it's really wide. So anything that gives value to the property, like, before it was done, whatever is done, now the property is worth more. Okay, that's a value. That's an improvement to the property. Repairs, removals of things, and soil remediation, even anything that gives extra value to the property. And then not just the cost of whatever has been put into it, but after something is done, then what is it worth? Is it worth more? Is it more valuable? That's another thing to look at. Okay, so it's really wide. It could be anything. You wouldn't suspect it, but sometimes it comes out of the blue. You say, what? But anyways, unplug toilet, get Roto-Rooter coming in, and then don't get paid. You put a lien on the property. Anyway, there's no minimum in terms of the dollar value, right? So that's important to know. Okay, next slide. So when you're acting for the buyer, okay, like I mentioned before, there's a new build and there's a contract of purchase sales. always specifically put that holdback provision in. And I mentioned before about there's a time frame to file a lien for the claimant, but there's a 10 days for the time in which to prepare a lien. So then there's a 55-day period, which is the normal standard that you have on any purchase and sale contract. It's 55 days holdback after completion, okay? And then in terms of, say the buyer doesn't really know when the place is completely purchased or not. So, you put the evidence of the substantial completion to the satisfaction of the buyer. The buyer determines when it is, not the seller. And you're protecting your buying client when it comes to this. And you get the evidence that you feel sufficient to show that this is conclusive evidence that everything's been done and all the subtrades have been paid. Okay, then you start, okay? If you can negotiate that in, that's really good. Of course, just like anything in the market, right? Sometimes it's based on the leverage between the buyer and seller, who has more leverage. Okay, next slide. I mentioned this again a little bit while ago, about the days. So, number of days if you're acting on behalf of a buyer, and if you're listing a place and you having a sense of how many days you should have that holdback for, it's 55 days, because there's a 10-day period of time given under the Village Lien Act for determining whether or not a contract has been substantially completed or not. So you have the 55 days, then regardless, that's going to be the time frame. Okay, next slide. No, I was going to talk to you about this. I alluded a few times over. This is an actual house that was sold in Burnaby. I didn't ask for the seller or buyer, but after the lien was claimed, then the buyer, who then became the owner, came to me, hey, 30 days after completion, there's a lien. What do I do? And so, a buyer entered the contract of purchase sale of home. Seller was aware there was a leaking oil tank, and then had to hire a oil tank removal and then a remediation company to do core samples and find out where the oil went. Turns out then they did core samples and it got higher concentrations as it was going towards the neighbor's house. So they got permission from the neighbor's house to do core sampling of the neighbor's house, and found that the continuation of the contamination continued into the neighboring house. So of course the neighboring house, who wasn't even trying to sell the house, all of a sudden, hey, it's got oil leaking from the seller's property. Well, even huge headache, right? So they put down the typical contract that would appear in a lot of the real estate councils, I think, guidelines as to the contract terms that you put in if there's an oil tank. The removal, the proof and completion of a qualified contractor to remove the contract oil. But there's hardly ever any, and I don't think there still is, any standard contractual terms that deals with the remediation of the soil if the soil got contaminated by leaking oil. So this was quite a number of years ago, and then after the whole thing had happened and liens got claimed and lawsuits started happening, one of the things that I found out is that the realtor involved told me that, hey, there's no guidance anywhere from the managing broker or any other real estate counsel as to what contractual term to put in the event that there's oil contamination. The realtors didn't know. They advised of course, the purchaser, hey, go hire a lawyer, go get some legal advice. I don't know anything about it. And they hired a notary, and the notary says, I don't know anything about it. It's legal advice, go hire a lawyer. But nobody was able to say to the buyer just how important it is to have a builder's lien holdback provision in the event that you think anything is being done to improve the house. And if they should I see a lawyer? I don't know. Go see a lawyer. I don't know. How much they cost? I don't know. But you should. But nobody, impressed upon how important it is. All it is like a term in the contract says the buyer is advised to seek qualified legal advice to give them a simple standard thing that relieves the realtor and the of responsibilities to be the one guiding or giving advice to the buyer, which is fine and dandy. However, and protect the realtor, but then put the buyer at a whole bunch of expense. And of course, once your buyer becomes the owner and there's a problem, guess what? They're going to try to find somebody to blame. Okay, and of course, then you're going to have a complaint 99.99%. All things were good before the buyer, but the realtor never told me just how important it was to get a builder's lien holdback, right? So protect yourselves, get that in regardless, and just get it in, builder's lien holdback clause. So, so after completion 30 days, the lien was placed on the house. Next slide. And then, if a builder's lien holdback clause was put in and 10% of the purchase price was held, which is what we should be done on a new build being purchased, 10% of the contract price. Just say, for example, $1,500,000 home. Okay, 10% of the price, stick it into, hold back from the sales proceeds into a lawyer's trust, and then wait. And 55 days has passed, do a search. Oh, there's a lien. Okay, well, the money was held back from the seller. Okay, it's not from the buyer, from the sales proceeds. Stick that into court. Boom, lien is gone. Not even the buyer's money is involved, none. You might have to hire a lawyer, but the 150 grand versus whatever, and whatever is claimed on the lien, whatever that amount is, done. You're done. You're over. The homeowner who was the buyer, the responsibility is all done. Go after the court money. See you later. So in this particular case, the amount of lien was $160,000 plus interest, because it's very expensive to remove an oil tank and remediate the soil. In this situation, they had to bring tons of soil to the remediation company out in Abbotsford, Sumas, to clean the soil. Right? They got to bring out, and the contract was based on per ton of soil, X amount of dollars. And then, of course, now they're digging into the next door neighbors to clean their house too. Think about it. Crazy. Next slide. And then, okay, 7 years later, interest compounded, or interest from the contract, the original contract price 7 years later is now worth this much. I can mention, if they held back, if it was like a 800,000 home, hold back 10%, that's all you would have done. The lien would have been gone. But instead, you have to fight, because you know why? The homeowner is liable for the entirety of the contract as much as the person who had sold the house, who was the actual contractor. Okay, potentially, like how much is the value of the home improved by the fact of the oil being contaminated, being removed? Now, the beneficiary of that service, guess who? The current homeowner that bought a house that did not have a lien on it, lien holdback place when they bought the house. Okay, serious stuff. The contract can be small, $50 for a doorknob or $500, but it could be thousands and thousands. Okay, hundreds of thousands of dollars. Okay, next slide. Yeah, so the entirety of the bill is a joint liability between the seller of the house that did the contract and the new buyer who had no idea, not even signing a contract, but is now liable for it. We did a 7-day trial in court. We won. Awesome. But then appealed, lost. And then during the whole time, I don't know if, try the next one. Next slide. Another twist. Another twist. And then during the time, the seller died. Okay. The seller who actually signed the contract, who sold the house, who got the money from the sale, died. Where is the money? Who's going to represent the seller? Then you have to go for probate, find somebody to apply for probate. Then you can have someone to represent the seller. This is the worst thing that could happen. This is going to drag in for another 2 years. Think about it. Just because it didn't take a 10% holdback, $80,000, $50,000, 7 years ago, stick it into court, hire a lawyer at the time of buying, if it's a brand new sale. Don't hire a notary because they can't deal with advice, dealing with legal advice. When it's going to be a new sale, and then you avoid yourself all kinds of problems. Okay, next slide. Yeah, not counting all the fees to hire someone to fight it and try to deal with it. Yeah, so I mentioned about this is that at that time they didn't have a contractual term that deals with the removal of the soil remediation. All it is just removal of the contract. There's an oil tank. Okay, have they saw the oil tank, it was removed. Okay, good, done. No, it's not done. Not done. Next slide. Oh yeah, then it turns out that last section there, they got a completion of certificate. Yep, all done, but not paid. Okay, important. Done is not paid. Paid, then you're fine. Okay, so you're happy with it because really it looked like a great job. Everything's done. Even the flower pots were put back exactly where they were before. They dug everything up. All the soil, brand new grass, looks great, but not paid. Okay. Anyways, the seller didn't pay. Nobody checked. Nobody got a certificate of completion saying it was paid. Nobody got the occupancy permit that it was all done and ready for. And nobody really checked to see whether or not the contractor was paid. No, important enough. Most important, nobody put a builder's lien holdback in the contract. That would save all this time and money. Next slide. So general rule, any kind of a new sale, there will always be deficiencies. There always never ever a perfect place, and always something a little bit off, a little bit here. Insist on an inspection to make sure everything's done right and well, and insist on that holdback if it's a pre-sale, regardless of what they say in terms of, oh, it's done, blah blah blah. How long ago? It's all done. It's all been paid. Don't worry. Anyways, put that holdback in. Okay, and it's just a holdback. It's just a short period of time, like even less than 2 months, and seller doesn't even get that much interest they put on the property, right? Like in the bank. Okay, next slide. Now, I talked about deficiencies because it's different than the builder's lien holdback. Because when you have deficiencies, things are not done, things are to be paid. Well, when you're buying a house with deficiencies, what do? How long it takes for the seller, if the seller's contractor, to fix things up? You might get into this little conundrum. Okay, buyer's going to take over and it's not all done because there's still stuff to be fixed. Well, then you can do a holdback in the contract. Not similar to a builder's lien holdback. It's just use the hold to make sure that the work that's supposed to be done is actually done. And then you can release the monies back to the seller so that they can pay the contractor who's supposed to fix whatever was not done. Okay. How long should be held back for when it comes to deficiencies for new sales? Well, always overestimate, especially in these times where, yeah, it's easy to fix, but you can't get the wood. Or supply chain issues. You normally in a normal time you can get the glass, but now you can't. You have to wait. So always overestimate the time frame to fix things up. Okay. And if you're not, realtors are not necessarily contractors and know how long it takes to fix something or build something up or repair. If you're the listing, you're buying whatever, get advice from a builder, whatever the issue may be, to give you an estimate of, hey, there's a problem getting this type of wire for the electrical system and panel, and it'll take you 3 months. Okay, done. You've got some advice on how much time to put in. Okay. When you do that deficiency holdback, you should itemize each one, so the idea, overestimate the time, overestimate the cost, but also itemize each item so you don't get into problems and back and forth between the buyer and seller, or this in terms of what was done and how much was done. So there's $100,000 worth of repairs, and then the seller and the contractor start working based on the holdback. They've done 80%, but the holdback says all done or nothing at all. Of course, that's going to lead to a lot of problems. I've done 80%. Why didn't you give me 80% back? Well, the contract didn't say if you get 8% done, 80% of the holdback is back, because it didn't say that. Then there's a lot of problems that happen. There's a lot of disputes. So it might be better to tailor the holdback so that you can tailor the items being done. If you've done 80%, you give 80% back and you hold back 20. That's one way to do it. And it's good to be clear and concise. If you're acting for the buyer, not disregarding the accuracy item, but the higher the amount you hold, the bigger the pressure it is on the seller to finish, or else if they don't finish, they don't get the holdback. So if it's $100 holdback, well, what are the chances of them actually doing the job? Yeah, it's only $100. I don't know. Oh, sorry, I said something Cantonese, but it's kind of like, I don't know if all of you speak Chinese. I think you guys do. I think you guys see. I'm looking all. Yeah, everybody goes Cantonese here. Good, except Frank. I don't know Frank. I don't see your last name, but I know everybody else knows Cantonese. Shunla, right? Forget it. It's like and then it's not get done, and then you got $100 to hold back, and then you got to use $100 to release to the buyer to able to use that money towards hiring their own contractor to finish the job. So overestimate how much, and then you have more to use, and overestimate to get pressure on the seller to make sure that they do the job. You know, doorknob, $5,000. Well, you don't get the doorknob fixed, you don't get $5,000. Okay, they're gonna do the doorknob, trust me, right? Okay. Okay. So next slide. So you know, insist on a deadline, okay, because you don't want to hang on forever. You know, oh, not done yet. Next week. Okay, not done yet. Oh, next week. You know, if you don't have a timeline, it may go forever. And the contractor's already on to the next big job, and they'll try to squeeze in some time between projects to come back to fix this crack, fix this door well. Put a timeline. If the sellers, contractors, whatever is not finished fixing, then all the money in the whole back, whatever is left, goes to this homeowner or the new buyer to use and hire their own contractor to finish the job. So don't let it hang on forever, because a big house is finished building, just a few little bits here and there. You know, unless there's a lot of money there, then you know it's pretty hard sometimes to give incentive. I think Min, we were talking about a client where you know you have to choose between giving a little carrot or a little stick. Okay, so sometimes the little carrot works, the stick works too when you have a big holdback. Okay, you don't do it, I'll take the money away. That's a stick. Okay, all right, there you go. And so then what if there's a disagreement? Not only is there a disagreement on how much is fixed, but if it's fixed even at all or not. So put in a clause that says the buyer's, you know, the purchaser's decision and discretion as to whether something is fixed is final. So there's no back and forth. It's fixed. No, it's not. It's fixed. No, it's not. You release it. No, I'm not. Then what are you gonna do, right? Anyway, so you should get you should get something in there to deal with disagreements, and you know, give your client, you know, if you're acting for the seller, of course, give it to your seller to decide. If you're acting for the buyer, okay, make the buyer decide. Okay, so you know, depend on who you represent. Okay, next slide. Yeah, so this is a sample. I just created one so you can see, you know, broken door, labor is 150, materials 200, put in $300, and you know, 2,400, but you break it up into little bits. So, you know, and then you have the provisions about how to decide when it's done and how long to keep things in there until it's done. So it's very controlled, you know. You have the time, you have the who decides, you have the amount, you have the dollar value, all clearly spelled out. So it's nice and easy and clear. So there's no confusion as to how things are to be paid and when and how and who decides. Okay. Next slide. And you know, one thing about this is that as lawyers, we don't get involved in the numbers because that's not our forte. We'll give you the format and the structure and the how to do it, but then fill in the numbers, because we may know how to read a 3,000-page contractual constitutional law argument, but maybe how to find a stud in a house, another problem. Okay. Now, next issue, GST. This is very common when it comes to purchase of a brand new home. Okay, and in the last little while, particularly when it's very common for holding companies to hold a company in order to develop a land, hold a land piece. Sorry, not hold a company, a holding company to hold the land which is being developed and sold. And then outside there's a beneficial holder, which is the real owner. That's the nominee that owns the land. It's very common. So nobody really has their own company buy a home to develop and build and sell. So the question is GST. Okay. When we act on behalf of a buyer, we want to say, GST is included in the purchase price because it's a brand new build. GST is automatically added on top when it's a brand new build. Okay, well then, what's the GST number, Mr. Builder? Now, as a buyer's lawyer, I would always check the company that owns the land and see if they're registered for GST. And if they're not, then I have to go to the seller and says, who is the actual owner of the land? Because the actual owner of the land on title doesn't have a GST number. So who has been doing the GST input tax credit? Who has been claiming the profits and loss or income and expenses from that project? It's not the person on title, because they're not registered for GST. And if they're not, you better get them registered right away, or else the seller cannot certify that the GST will be collected and paid, because we don't know who the GST registered is. Okay, very important. It may sound, geez, do I have to know CRA and GST rules? At least you know some of the background, okay? Because the owner of the land does not necessarily the real owner. Quite often there's some agreement called a nominee agreement, sometimes called a bare trust agreement, sometimes called a joint venture agreement, sometimes called a limited liability partnership agreement. But in the end, somebody else actually owns the property, not the person registered on title, not the company. You look at the company and you pull out the companies and you find out who owns the company. You look at the shares of the company, it's held by another company. Then you have to follow, well, who owns that company? Well, that company, check the shares. Well, there's another company owning the shares of that company. Then you keep going on and on and on. This is precisely a segue that the Landowner Transparency Register, there's a deadline. It's a good time to talk to you guys about this. If you guys have acted for companies that purchase properties in the last, whatever, how many years, it doesn't matter, and they still own the land, that company is supposed to file a landowner's transparency report to the Landowner Transparency Registry. And the deadline is November 30th of this year. And if they don't, they can face fines up to 20,000 for not reporting. And I mentioned this a little bit ago, but just about a company owning land, but it's a nominee for another company that really owns the land, which is held by another company. So the Landowner Transparency Register is meant to shed light. Who really owns the property? And are they non-residents? Are they foreigners? Are they people who are not in Canada? No SIN numbers, because you have to report people, not companies. Are they residents of Canada? Are they non-residents? Are they citizens? Do they have a SIN? So anyways, just a segue, because it's not that easy. And we've been notifying all the clients that we have in my office, where we are the registered records office for. If you own land, you own properties, you need to file this LOTR by November of this year. Anyways, so, the question, these two issues here, right? So next issue, next slide. So the mention about beneficial owners versus real owners. So maybe on behalf of a buyer, to investigate, your buyer client has to find out who. Now, two things you can say for any new build to save, if you're acting for a buyer, to save yourself a lot of hassle. And if the seller says, look, I've finished building it, but it's been lived in now, and now it's no GST. Oh, okay. As a buyer, put a clause in saying, if GST is applicable, it's included in the purchase price. The buyer's off the hook. It's already in the price. If they find it's applicable, I already paid it to the seller, go after the seller, okay? Now, the idea is that if you have a sense that, that the house is recently built and like less than a year, okay, and someone's living it, it may very well be that it's still not GST exempt, because whether or not a new build is practically now a used residential home is not a science, it's an art form, okay? So how long has it been lived in? Has it been principal residence? And I would say normally, if it's a new build and a year and a half after it's built, and there's people living in it for at least a year and a half after it's built, then you can feel a little bit more comfortable that it's a used residential home. But if it's not, be careful. You can't just say and rely on representations that it's been lived in. Oh, don't worry, it's lived in. Therefore, it's used. It's not that simple. Okay. Yeah. Anyways, so how do you can check on a GST registrant? The CRA website and CRA GST search, and then give you a list. Type in the name of the company. Click. It'll tell you is it registered or not. Okay, so we do that all the time as part of our due diligence when we act on behalf of buyers who are buying from a new builder owned by a company. Okay, and even if it's not, even if it's not a new build, then if it's owned by a company, it could be a commercial inventory in terms of the GST terminology. A homeowner can be say, hey, I'm going to register a company to own one piece of land in order to build it because I get no benefit from having an investment property held not in a person's name. And then the CRA may turn around and say, yeah, that you're holding land as inventory. And if you sell inventory like a developer, an inventory of supply, you are now a GST applicable property you're selling. You know, how did that happen? Well, if there's any issues, of course, call and find and consult with a GST lawyer, accountant. If they're tax lawyers too, but they're more involved with fighting the CRA. So, get an accountant to give an assessment if there's any questions. But yeah, I have those issues ongoing all the time where the seller is represented by notary. And then I say, look, the GST is not registered under the seller. So, and what does that mean? Well, it means they're not the real owner. Where's the nominee? I need a bare trust agreement. I need the nominee agreement, the joint venture agreement. Give me the documents to determine who the real owner is. And no, it's just a verbal agreement. Hey, Bob, uncle, bong, help me buy a property. That's not good enough. Anyways, next slide.
There's a question, Ivan.
Oh, okay, good time. Is there a chat?
Yes.
Okay. Okay, I'll open the chat here. Oh, yes. So the question is, we don't want to say if applicable, we want to say the price includes G. I am good. Oh, good one. Man, I taught you well. Awesome. So I was just making sure everybody's awake. Okay, no, just joking. But yeah, you should actually say GST is included. And then there's an even better way to protect the buyer, because if if you say if applicable, and then when I mention about it, willful blindness, you put down if applicable, but you should have known it is. The buyer would have known because look, it's less than a month old. How come you say if applicable? It is. So you want to protect yourself even more. As a general blanket, yeah, put it as GST is included in the purchase price. Yeah. Thank you, Min. Thank you. Good job. Yeah, good. Hopefully that answers is good. So what can be done if the real owner of the new build on title is not the registered owner? Okay, so we have to, as a buyer, it's one of the things that we have to investigate title ownership. So we have to register, we have to investigate, check and sign certificates of GSTs so that the seller confirms that their GST is non-exempt and they have a certificate. Because when you ask the seller to put their money where their mouth is, to sign off on a document to confirm it, that's different than saying it just in the contract. Okay, contract, I promise, but then it's not confirmed, not acknowledged, not certified. It's something, and these are forms that real estate practitioners, they all know the GST certificates that needs to be signed on behalf of the seller. But be careful. If you know and you search and you know that the GST person on title is not the registered owner, and then the vendors give you a GST certificate signed by the one who's on title but who's not the GST registered confirming something, well, that's not good because you're getting the wrong person to confirm something. Okay, so anyways, next slide. Sometimes what I require is something to actually prove that the separation of the legal ownership from the beneficial ownership has been put into a paper. And you sign a transfer, you sign a nomination agreement, you sign a bare trust agreement, give me the joint venture agreement, something signed. And if you don't have one because it's verbal, get it signed in paper and then get it to me. So I've done that before where I insisted on it. We're not transferring the legal ownership unless the beneficial ownership goes along with it. Okay. I might have talked about beneficial versus legal ownership in another thing before, maybe, anyways, we should talk about that at some point. Then there's a document called the quitclaim, which is actual transfer of the nominee of the bearer trust. I mean the beneficial interest to how you say, consolidate the beneficial ownership back into the legal. So when the legal ownership is sold, everything goes along with it. It's almost like two parcels of land, the legal and the beneficial. When you sell it, both should go, legal and beneficial interest. You can't just hold title but not really own the property, which is the beneficial interest. Next slide. Sometimes about fixing the issue by registering a formal transfer. Now, that has happened recently. I did the search. I found out, hey, Mr. Homeowner, Mr. Vendor Lawyer, the notary, the registered owner is not the owner of the GST registrant. And then they did some discovering. Oh yeah, Brother A asked Brother B to hold the land for them while they develop the property. Well, that's not good enough if Brother B doesn't really own it and Brother A does. So then they said, oh yeah, okay, we're gonna do a transfer so that the ownership is in the actual person that should actually be the owner, which is Brother A. That like a week before completion. Now, my buyer client, quite often when they get a loan, they have a bank, and the bank requires something called title insurance. You guys may have heard about it and talked about it, but usually you don't have to get involved in it. It's something just the lawyers have to do or the notaries. But it's the bank's requirement to get some protection for the bank in case there's something they don't know, they can't check and can't look at title to find out. It protects against misrepresentation and costs money. And then, the buyer or lawyer gets title insurance. But title insurance, at the end of the day, they're an insurance company. They protect against risk. And the underwriters will look at this and they see the recent title change that happened 1 week before completion. Ding, 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 alarm bells. Why? Who is it? Does the real owner not really own it? Who else owns it? Then that's risk, because do we know something that we don't know, or do we not know something we should know or should know? And then they hold on title insurance. No title insurance, the buyer doesn't get the mortgage. Buyer doesn't get the mortgage, the buyer can't buy the house. And you can't buy the house, then you have to extend completion. All because the seller tried to fix title before they sold. Okay, a big issue, and then we're able to resolve it when the lawyer for the underwriter for the title insurance had to contact the lawyer for the seller, the notary, and to do investigation. Okay, and then they had to be satisfied that they're not on the hook for something that shows up. Somebody somewhere, someplace, somewhere else really owns a property and didn't agree for the house to be sold and put a lien on the property, claiming fraudulent conveyance. Boom, issues all over the place. Okay, next slide. I think I just talked about the next slide. Yeah, I did. Next slide again. So title insurance, right, causes a real issue. Okay. As I said, without title insurance, without mortgage, you can't buy the house and go on from there. Okay, next slide. I talk a little bit, the last little chunk here about leaseholds, because, brand new property on a leasehold land, because land could be, not leasehold or leasehold. There's separate issues that come up that are very unique to leasehold properties, and you'll have them around UBC and Simon Fraser and some more parts of the Falls Creek area, and also the Musqueam and also the Tawasin lands out in Delta if you deal with those areas. Okay. So the tripartite agreements, what are they? If your client is buying a leasehold property and they're getting a loan, invariably they have to get tripartite agreements done. Now, what are these? Next slide. Now, and oh, there we go. Okay, so before actually I talk about it, before I talk about tripartite agreements and who signs it, you have to talk about the parties, like who is the owner. A leasehold property, just like you can analogize it to a commercial leasehold. There is a landlord and there's a tenant who's a lessee. And so when new people are buying leasehold, they're assignees of a leasehold. So they're just being assigned over and over. So who needs to consent to that? Well, of course, if it's a UBC land, the UBC trust landlord has to approve it. SFU, the SFU has to approve it. And if you're getting a loan, of course, the bank has to sign it, then the owner has to sign it at the end. Give yourself time, because SFU and UBC, they're all busy people and they don't respond necessarily to the timeline for completion, not like a strata property management company when they're doing strata forms, when you're requiring for strata forms. You order strata forms from strata, they have 45 or 5-day period, pay this much. You're in a rush order, you can pay them more, and you have to get it before the completion date. You can get them to give you the Form F before completion of Form B. Not necessarily, landlords. Okay, so give extra time to get those documents in. Vancouver, so you find them around Falls Creek areas, sometimes UBC, Burnaby Mountain for SFU, the First Nations land, which are the lessors. And if you're getting your client is selling or buying leaseholds on First Nations, give yourself even more extra time to make sure all the documents needed are done before the completion date. Okay, give extra time. Don't think that, oh, financing is coming and there's enough time a week before completion. If it's on a leasehold land, give a couple more weeks. It takes that much time to get it. You can't pay more to get faster service, not like strata management companies, okay? And they're not in there to make a profit. They're not in it to make money. They just have to make sure that anybody who's a lender who can potentially foreclose on their property will make sure that the landlord, UBC, has the first crack at getting that property back before they open it up to anyone in the public, so they can control who are the leaseholders, the assignees of that particular area. Okay, I think that's about it. Did I miss anything? I saw that we're on item number 6, but I don't know, did I cover everything? What was 5? If you go back a little bit, make sure I covered what I wanted to say. 5 was, sorry, going backwards. Oh yeah, rules. Something else to watch out for when you're doing due diligence on leaseholds is to find out what the rules are. Not just the strata, but what are the rules of the property. Now, UBC, for example, they have separate payments to be made for a UBC services levy, which is separate than a tax, and it's not utilities, but it's a separate thing. So when you do property tax searches, you have something separate to do, which is a services levy for managing the whole entire UBC leasehold land. So, and then you look at how much time is left on the lease when your buyer comes in. Nor typically they're 99 years lease, and then once the lease is up, they may renew all the rules required, including the payments that needs to be made to maintain and keep that land. So it's important to look at those as well. Okay. I think, let's see, number 4. Did I miss anything there? For what is more? Yeah, I talked about why tripartite agreements are needed for the bank's purposes, and not the bank's purposes, for the landlord. You want to make sure that they're priority over any bank that comes and who tries to foreclose their property and resell it. Okay, I think those are all my topics today. Yeah, and we have a little bit of time, I think, for questions, I think. And at the end of this, Calvin, I don't know if you're, like I usually do in some of these things, I have a question that if the first person on the chat gives an answer to based on something presented, then you get a Amazon gift card, and so you can, as long as you have, I don't think you need to have a membership to use it, but as long as you have a gift card, you can access it. So there'll be a prize after questions and answers, and you guys can enter into a little skill testing draw based on the presentation. Okay, sounds good. I guess there's any more questions, or should I open the chat? Chat. Any questions, guys? If not, we can go. Evan, do you have anything you want to talk about, or refer to all the participants today about anything that I said so far?
Ivan, I have a question, if you don't mind.
Who is this?
It's Teddy.
Oh, hey, Teddy. Yeah, no problem. Yeah.
Hi.
Oh, yeah,
So
you can do that too. You don't have to just type it in the chat.
Yeah. This is actually kind of a long question, so it take you on to type. So my client is buying it's a new construction. The house is almost completed. On title, it's the owner of the house.
Yeah.
But we have in the contract that yes, GST is included. But then you mentioned that does that owner need a GST registration number to pay the GST? Like, would it be safer for us to change the contract price to not include GST and just have
No,
my
no, no,
clients
no.
pay it?
No, 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 no.
Or it's okay?
Whether or not the seller is registered or not is two different things. If it's the
Okay.
owner themselves, the likelihood is that they're owner builder rather than contractor builder rather than so to answer that question first, no, it's not better to say it's not. The reason is there's a couple of ways for GST to be dealt with. Of course, the buyer has to pay, but the seller is by law required to collect and remit. Now, if they're registered for GST, there could be something called a GST joint collection. So if in the event that the buyer also has GST and the seller is GST, then they can elect not to have it remitted or collected. They can just agree. So that's a situation where a buyer has a GST, the seller has a GST, boom. Now the buyer doesn't, but the seller doesn't. Then the seller is required to remit it because they're not GST registered. They have to remit it to the CRA. They're required to do so. So, saying it that they don't have to say that they don't have to see is included doesn't mean anything, doesn't help anything. Let's just say.
Okay.
Sounds good.
Yeah, I just want to make sure it gets paid. That's all.
Yeah,
I'm like,
exactly. So whoever's supposed to pay, if the buyer paid because it's included. Now the
Yeah.
seller has to remit it.
yeah, I just want to make sure that
Yeah.
it does get paid. My buyer doesn't have to pay extra.
Yeah.
So that's
Yeah.
it. Okay,
Yeah.
good. Thanks.
Good job. You put it in. It has to be in. So, and I think Min, thank you for that. And of course, any of you that have, examples where you guys are working on something and you got something to share too. That's always a good time when we get together and have meetings like this. I'm presenting, but it's a nice forum for everybody to share things too. Okay. Yeah.
Ivan?
Calvin. Yeah.
No, Ivan, this is James. I have a question.
Oh, James. Sorry. Do you have
Hi.
your? Are you on? I don't see you.
Oh, I don't have my camera on.
Oh, okay. Sorry. You're in your pajamas at home. You're having a hot chocolate and having a day off. Okay.
I wish.
But thanks for coming in anyways. Okay, and joining in. Yeah, go ahead,
Have
James.
you dealt with any leasehold that's expired 99 years? Like what happens, what can happen after 99 years?
Well, the landlords, whoever that may be, develop the new lease term and the rules and fees and fines and costs and how to evaluate things, and then the homeowner is who owns the assignment is at the mercy because there's no negotiation.
Right. So either they take the new agreement or they walk away, just like that.
Or they try to sell it to someone who's agreeable because otherwise you're stuck with it. You're stuck with it.
Yeah, but are you able to just walk away if nobody's buying it?
Well, not walk away. It's almost like you own a house. Your name is still going to be there. And
Okay.
then, what happens if you don't pay? Like, say, for example, city property taxes. You walk away from the house, leave it vacant. City doesn't get paid. The city tries to foreclose. You don't pay the lender, or the bank tries to foreclose. Somebody will try to take the house and sell it and remove, whatever, right?
Okay. So you cannot just walk away. You have to somehow deal with it, either sign the new agreement or somehow get somebody else to deal with the problem.
Yeah, well, the idea of walking away is like, abdicating responsibilities. No, if the house is sold, the bank forecloses, well, then they can find some recovery for their costs. And then maybe you are off the hook because they're not coming after you, but you've lost what could have been something that's worth something. Right?
What if after the 99 years, and I think the Falls Creek one, they're taking back the land and building like new buildings, right?
Yeah.
So will they be compensating us, or
there's nothing there that says something that it's actually worth something before it's actually done.
So it's possible they can just take it back and say we're not going to renew.
Yeah, and not sell back, and we're gonna. Imagine the strata where they have a resolution to sell the whole thing and all the strata owners have no choice but to give it back to the developers coming in to buy. The vote's been done. Now you got to do it, or else you're out of luck. You want compensation when it's been decided already, and people who are buying leaseholds have to acknowledge that there is this level of risk. Okay, and when you buy a pre-sale, then you'll get something of the same footage, but the bathroom is completely different. There's a patios on the left side and on the right side. That's an inherent risk of a pre-sale. Inherent risk of a leasehold. Well, 99 years is up. What's going to happen? So the value normally sometimes of a leasehold when it's less than less years is uncertainty. So the value of uncertainty is given and factored into the price normally, right?
Yes.
Yeah.
Yep.
Yeah.
Okay, thank you.
Yeah. You're welcome, James. Yeah.
Ivan.
Who's this?
Hi, this is Min.
Oh, hi, man. Hey, sorry.
Hi, thanks. Yeah, first of
No,
all,
no,
thank
thanks.
you for saving me from a few troubles that I got in.
No, yeah,
Thank you
yeah,
so
yeah.
much.
You use
So,
the carrot, sometimes use the stick. It all works.
yes, yes. So I have a
Money.
question for you.
Okay, yeah.
Like, for example, you say for doing a holdback for, for any repair that needs to be done. Like, if I'm the buyer agent, I would put in, like holdback, okay, until this item 1, item 2, item 3 that costs an amount of cost to
Oh, sorry.
finish.
Hey, man, can you speak a little bit louder? It's hard to
Oh.
hear. I'm sorry. Yeah.
Oh,
You can
now?
start over. If you can apologize, you
Okay.
can start over.
Yeah, sorry. So I was saying, if I'm representing a buyer and we have the property that we're buying have some problem, deficiency, so what I do is I would put in a holdback
Yeah.
clause there. So itemize all those things, putting all the costs, how much each item costs. So
Yeah.
putting a deadline before those things need to be done.
Excellent. Yeah.
Otherwise, we'll do it ourselves, and then money will be taken out. But what if we are the receiving end, meaning we are the listing, we're listing the house and people are buying and they put that clause in, and how can we be sure that after we do all those repair, the buyer is still not satisfied? Like, where can we find a referee that can judge, okay, item 1 to 10 has been done completely, holdback shouldn't, no money should be held back anymore?
Yeah. Yeah. The idea is in that situation is kind of like an objective statement of whether
Yeah.
something's done or not. And if that does come, like normally, like I mentioned before, you can put in a clause, the buyer's contractor's statement that everything is done or not done is conclusive proof of it being done or not. You can do the reverse. You can the seller's contractor, blah 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 company, is their statement of whether something is done is conclusive. Sometimes you can do that if you can negotiate that into the contract. If you can also appoint a third party, right?
Oh, okay.
Home Depot contractor, Lowe's contractor, or someone works with, and you pay them to do it.
Right.
They come in to do, hey, this was what was done. This is what the problem was. Can you tell me, is it fixed? Mr. Home Depot. Mr. Home Depot signs off saying done.
Oh, okay. Okay.
Right?
Yeah, because
Someone-
okay. And then last question, like for lien, the only place to check is on title and nowhere else. Is
Yeah.
that-
Yeah, the lien,
Okay.
well, register lien. That's the whole point, is a lien on property to force a payment. Sometimes you check title, the lien is being held by the lien claimant lawyer walking to the, not locking, now it's all digital.
Yeah.
Used to be you walk to the land title office and you file it.
Right.
Now, it's all scanned and ready to click.
Right. Okay.
Digitally signed, ready to file. But you can't check it until it's filed. But it could be there, it could be in the process of happening. And you did the title search 10 days before completion, nothing there. You do a search on completion, there it is. So yeah, that is, you can't check it until it's there.
Okay. All right. Thank you.
Yeah. So good. Are we all good? Oh, everybody's,
All good.
some people signed
Hey,
up.
Ivan.
Yeah.
Hi, Ivan. This is Gerald. One more, please.
Oh, hi, Gerald. Hey.
How are
How
you?
you doing? Good to see you.
What happens if, let's say, after completion, you find a lien appears on title? Who pays? I don't really know how to phrase this question, but there's a 55-day, I think, limitations period. Is that what the builder has?
There is, and the question to answer that depends on whether a lien was actually collected or not, a holdback, and was a lien holdback put into the contract that allows the buyer to hold that money back. And if there's no clause, nothing was written down, then the homeowner who purchased the home, who finds a lien, can be liable up for the whole entire value of the contract, can be.
Right.
That
So,
wasn't taken.
so does it mean that the builder has up to 55 days to place a lien on that property, register a lien on the property? But if after 55 days, then if the builder places a lien on the property, that lien is illegitimate? Is that what it means?
It could mean that. No, the idea is that in the contract, if it says, for example, that the 50-day period starts from the date of completion,
Yes.
and then after that they stick a lien on anyways, then you can apply to remove it because it's after the time frame. But if for example, if none of the contractual words in the contract of purchase and sale says anything about it, no mention at all, nobody talks about it, then all of a sudden a lien gets placed on, there's no 55-day period of time.
I see.
There's nothing written down.
Yes,
In
yes.
fact, that's there's no holdback. Nothing was
Right.
cut, and who's
Right.
liable for it? You got to fight it in court.
Yeah. Okay, I got it now.
Yeah, that's
Thanks.
why you should actually, if there's any new sales, new builds, stick in all the contractual words to protect the buyer. Yeah.
Right, right. Thanks. Thank you, Ivan.
Oh no, you're welcome, Gerald. Yeah.
Thanks. Bye-bye.
Yeah.
Bye, everyone.
So, ready? We're all good? Okay, so are we ready for the question? The first person to put on the general chat line for everybody, okay? So how many days? There's a provision in the Builders Lien Act that says the lien claimant has X number of days to file something in court to prove their claim. How many days is that?
55 days.
A builder's lien has been placed on title. Now they have X amount of days to actually prove their claim if they were given this notice from the homeowner. This is the put your money where you, there you go, Teddy, you got it. 21 days for the lien claimant to put their money where their mouth is, okay? So the idea is that the lien is put on the property, but it could be fraudulent. They're putting it there for $5,000 when all they ever did was sticking a copper wire inside inside an outlet. Okay, they want more money because they know the house is being sold, or whatever reason they want to exert pressure. They want to put a carrot to the owner to make the stick to force the seller to pay money, to hold them as ransom. So 21 days. Good, awesome, good job, Teddy.